Hello, ladies and gentlemen, and welcome to today's webinar. My name is Daniel Weiner, and I will be hosting today's webinar. I'm also the Chief Executive of the Employment Division at ReadyTech. In terms of what we aim to cover through this webinar, at first we will do a quick welcome and introduction. That will be by myself. Then Lee Pike from Holman Webb will be taking us through the annualised salary changes. Post that, Paul Orford, the Product Compliance Manager, and myself from ReadyTech will be taking us through the practical implications, and then we'll open up for Q&A. At that point, we'll also welcome Andrew Anderson from Flair HR to give us a bit of an update and background as to how Flair may be able to help us through those processes. I will just remind everyone, today's webinar, everybody has automatically been placed on mute. We will be opening up for Q&A. So at the bottom of your webinar software, the Zoom software, you will see a Q&A area. At that point, at any point throughout throughout today's webinars, please feel free to ask any questions through there. At the end, we will review them and answer them, time permitting. So if we move on to the next slide, here's a quick picture. It's always hard on a webinar to see who your presenters are. So it's again me, Daniel Weiner, Chief Executive. Soon there will be Lee and then Paul. To give you a little bit of a background, many of you may have heard of ReadyTech before, most likely through our software applications of either HR3, Aussie Pay and the Outsourced Service, or ePayroll. As an organisation, our core focus is to make sure that we're getting people ready for the future of work. And today's topic probably is square in that point of not just the future of work, but how we make sure that we're enabling employers to help fulfil their requirements to ensure their employees are being paid right and also managed in the right way as well. From a ReadyTech perspective, we're a listed business. We listed on the stock exchange in April of last year. And our core mission is to really make sure that we can ensure that life cycle management is taken care of for you as the employers. You'll see on this next slide what I mean by that life cycle management. Every stage of this life cycle, from helping you find your employees through new recruitment modules that we will be adding, and then the core piece of them once they're onboarded, how do we make sure that we've taken care of that life cycle? So full-time attendance requirements, making sure that all of your legislative requirements in terms of single-touch payroll, the state taxes, PAYG, whatever is taken care of, we go through that life cycle with you. Once you're enabled to be able to manage that payroll successfully, then we want to make sure we're taking care of the next stage, that human resource management. And over time, we'll be adding more features and functionality to help you manage your staff better. Ultimately, people do leave, whether we like it or not. And so we also want to make that as streamlined as possible, not just from the termination payments, but also through to making sure that we're learning as much as we can through that process so that you are empowered to have that process taken care of. So it's really that core focus of what we're trying to achieve here at ReadyTech in our employment division. Moving on from this now is really when we get into the crux of it, and we're really lucky today to have Lee Pike from Holman Webb to take us through the legal view of the annualised salaries. I've said this now a few times, but there is never a dull day in payroll, and today I think is a perfect example with everything going on. There's a lot of confusion. So Lee will be taking us through that. So Lee, are you there?
Yes, I am, Daniel.
Okay, perfect.
Yeah, so,
I'm going to hand over to Lee now. Thank you.
Perfect. Thanks, Daniel. So my name's Lee Pike. I'm an employment lawyer by background, and I've been practicing in employment law for about 7 years now, sort of exclusively in employment law. In I guess part of my practice has always been advising in terms of payroll, award interpretation, that sort of thing. So that's a lot of my background, and that's what we do at Holman Webb as well. So today, just to give you a brief overview of what we're going to be discussing, a little bit about the modern awards, the history of how we got to the point where we have modern awards. It's not a particularly historical concept. It's about 10 years old now. We're going to talk about the decision on annualised salaries, so what the Fair Work Commission actually decided in relation to annualised salaries and how that decision in particular came about. We're going to look at the affected modern awards, so those modern awards that now have an annualised salary provision within them. And then we're going to look at the model annualised salary clauses, what these provisions mean, what they actually do in practice, and what that means that employers need to put into practice, and how that, I guess, affects then the obligation of payroll and the back end of dealing with that process. Now, the model annualised salary clauses came into effect from the 1st of March. I notice now we're at the 16th of March. So I don't know where this year's gone so far, but not to fear, we'll have a chat about what they mean and what sort of came into place from the 1st of March. Now, looking at the annualised salary provisions in the context of, I guess, the historical how, where, why, one of the key aspects of the Fair Work regime, when it was introduced by the Rudd government in 2009, was the rationalisation of modern awards. So you might recall that prior to 2009, there were hundreds and thousands of different awards that applied across various industries and occupations, which then need to be rationalised. And the Australian, and I guess that was done as part of that 2009 award rationalisation process. Now, from that process, there were born 122 modern awards, which then predominantly applied on an industry basis. So there's 93 industries and occupations that those 122 modern awards apply to. The ACTU actually estimates that 1 in 5 workers are covered by a modern award. So 1 in 5, 20% are covered by a modern award. The ABS statistics, although they're a little bit outdated, the 2010 ABS statistics say that 15% of workers have their pay set by a modern award. So we know that the modern award sets the base rate of pay, the safety net, if you will, and we know that 15% of workers have their pay set by that minimum. That obviously isn't taking into account contracts and enterprise agreements that are individually struck with either enterprises or individually with employees. But still, I would guess a relatively high percentage of employees relying on the modern award to determine their base rate of pay, therefore relying on wage increases to determine their rates of pay year to year. Now, a key aspect of the introduction of the modern award system was mechanisms within the Fair Work Act whereby the Fair Work Commission would be empowered to review the terms of all modern awards. So specifically, the Commission was required by virtue of the Fair Work Act to undertake a review of all modern awards every 4 years. So that's called the Modern Award 4-yearly review. Now, the current review started in 2014, so that was 4 years after the Modern Award rationalisation process had completed and the Modern Awards came into effect. So 4 years later, the Modern Award review commenced. It's scheduled to finish this year. So if you're counting, that's 7 years from start to finish. So the intention, obviously, every 4 years was completely thrown out the window. And yeah, it's been a very extensive process. It certainly hasn't been a quick check or fix or smoothing out those lumps and bumps, which is what the intention was, but it certainly was seen as a little bit of an opportunity, I guess, for businesses, for industries to make applications to make fairly substantial changes to their modern awards. Now, moving on to, by way of a background, I guess, into annualised salaries and how they made their way into a number of modern awards. It was actually the National Farmers Federation who was part of the award review of the Pastoral Award, made an application for the insertion of an annualised wage arrangement in that award. So it was one industry, one association certainly that made that application. And that application relied on the section that you can see on the screen in front of you, section 139, subsection 1, subsection F. And this particular clause provides that a modern award can include terms about annualised wage arrangements. And the provision continues to state that those annualised wage arrangements must have regard to the patterns of work in the occupational industry. The arrangement must provide an alternative to the separate payment of wages and other entitlements, and that arrangement must have an appropriate safeguards to ensure that individuals are not disadvantaged. Now, the full bench that was determining the issue, so that was the issue that had been brought by the National Farmers Federation, they wanted to refer that issue, the specific issue of annualised salaries, to another full bench. And they wanted that full bench to look specifically at that application. And they wanted to pay particular attention to subsection 3, so whether or not the arrangement included appropriate safeguards to ensure that individual employees are not disadvantaged. And as part of that process, so sending that particular review to a new full bench, they wanted the new full bench to have regard to the clause as it existed in another 19 awards. So the annualised salary arrangement already existed in 19 awards, and one industry was asking for it to apply to their relevant award, and they were the new full bench was constituted to look at that application and the existing 19. So the first decision came out on the 20th of February 2018. The full bench comprised of Vice President Hatcher, Deputy President Dean, and the then Commissioner Saunders. He's now Deputy President Saunders. They delivered the first of 3 decisions on the 20th of February 2018. And that particular decision, so that first decision, determined that the current annualised wage provisions in the 19 modern awards didn't actually provide appropriate safeguards to ensure that individual employees were not disadvantaged by these arrangements. So it essentially failed to adequately address that subsection that we were talking about. So consequently, then 4 model award clauses were drawn up, depending on whether the industry and the particular award was focused on employees that worked stable hours or those that worked highly variable hours or significant ordinary hours that attracted penalty rates. So at this stage, what we know is that one industry wanted to change their award, and we end up opening the matter up in a commission, and it was opened up as a common issue within the review process for there to be that review extending to another 19 awards that already had those annualised wage provisions. So the Fair Work Commission essentially said, we can't put it in an award unless we're satisfied that it's correct. So we need to make sure that what we've done is already correct before we do it. Before we apply it any further. I guess they're anticipating that it could have been extended as well. So it was one industry that applied at this point, but it certainly didn't prevent other industries from applying for that particular provision in their awards. So they wanted to get it right. We can see, I guess, from that mindset, why the modern award review has extended past 4 years and has extended to 7 years, given how the Fair Work Commission sort of approached these issues, wanting to look into every little nook and cranny. Not that I'm saying it's a bad thing. Now, moving on to the model clauses and what awards they actually apply to. So on your screen now, you'll see a table that has a number of awards in it. These are the awards that apply model clause number 1. And I'll talk a little bit about the difference between model clause number 1, model clause number 3, and model clause number 4 in just a minute. But I did say earlier that there were 4 model clauses that were drafted. It didn't, however, model clause number 2 didn't make it to be applied in any awards. So it's just, we're talking today about model clause number 1, number 3, and number 4, just to be confusing. So these are the awards that apply model clause number 1. The next slide that will show you applies model clause number 3. The model clause between model clause number and number 3, model clause number 1 to the industries that stable hours, and model clause number 3 applies to industries that generally have highly variable hours or significant hours that attract penalty rates. as their ordinary hours of work. So where there's a little bit more, say, shift work, and it's not such a Monday to Friday, 9 to 5 sort of industry. The next slide we see will be those that may be relevant to model clause number 4. Now, model clause number 4 hasn't been completely decided yet. It's likely that it will be added to these particular awards. That's the Restaurant Award, Marine Towage Award, and the Hospitality Industry Award. It hasn't been applied to these. It's a little bit of a wait and see. Now, the difference between model clauses, the model clause number 4, is that it applies on more of a percentage basis. So anyone who's paid a certain percentage above the base rates of pay in that particular modern award is receiving a salary that exempts them from certain conditions. So those things have been predetermined, a little bit less so than the industries and the awards that will apply model clause number 1 and model clause number 3. We'll have a bit more of a chat about that in just a minute. So what are we actually talking about when we're talking about annualised salaries? And what do they actually mean? What are these model clauses? Annualised salaries, I just want to run you briefly through the terms and obligations of the clauses. They have a lot of common features between the clauses. So yes, there's 3 different ones, but they are quite similar. So just generally, the annualised salary provisions only apply to full-time employees. So not part-time, not casual employees. Employees who are provided with an annual salary need to be notified of the annual wage, so what it is that they're actually receiving on an annual basis, what provisions it satisfies. So is it satisfying allowances, overtime and penalty rates? Is it incorporating annual leave loading? So it needs to be spelled out what in particular that annual salary is set to incorporate. The employee needs to be notified of the number of ordinary hours that usually attract a penalty rate. So how many hours are incorporated, say, on a per week or a per month basis that would normally attract a penalty rate that are being included into that annual salary. And also the overtime hours expected to be worked without payment. So what that actually looks like. And, in that sense, how many hours are you going to be performing before overtime penalties are paid in addition to your salary? And Paul's going to touch on that when he presents in just a little bit. Other common features, the annualised wage must be no less than the modern award. So obviously that falls back into that, I guess, what the Commission was looking at, which is we don't want anyone to be disadvantaged. So it can't be less than what an employee would have received under the modern award. Now, the next few points are they're a little bit more difficult and they're a little bit more onerous. They're slightly different, I guess, to what would have been historically done in this space. But there needs to be, for any employees who are on an annualised salary in accordance with these provisions under the relevant awards, there needs to be an annual reconciliation of the hours worked and the salary paid. So that needs to be either on an annual basis or it can be on termination of an employee's engagement. So if that's before the end of a 12-month period, before that reconciliation can be performed on an annual basis, or alternatively, at the cessation of an annualised salary arrangement. And that relates in particular to those awards that have model clause number 3. And I'll talk about that in a minute, what that means. Now, as part of that reconciliation process, the expectation of the Fair Work Commission in drafting the clause this way is obviously that it's not always going to be correct. You can't always accurately predict how many hours are going to be worked, how many hours are worked. They're not expecting that reconciliation to be so regular that no mistakes occur. So they've written the clause in such a way that if you do that reconciliation and if there is a shortfall, that shortfall then needs to be paid promptly within 14 days. So if there is any disadvantage, that it's rectified quite quickly. Now, the clause also says that hours worked and unpaid breaks of employees that are under this arrangement need to be recorded. So that's starting and finishing times and unpaid breaks. So we know how many hours the employee's working and what breaks they took in that particular time. And the other thing that these provisions provide is that employees need to sign off or acknowledge that the hours are correct, either each pay period or each roster cycle. So there's a record then for employers as to what hours were actually worked. It's not a guessing game, which is probably what it's been a little bit historically. So keeping in mind, I guess, the reason that those things were entered into, the catalyst for these clauses was to ensure that there were appropriate protections in place so that no employee was disadvantaged by salaried arrangements. And I want to use I guess the example in the media at the moment. We're seeing a lot about wage theft. I won't give you my thoughts on that term wage theft. Believe me, I have some, but we're seeing a lot of underpayment claims. We're seeing them from a lot of big organisations that are award covered. So your Coles, your Woolworths, your Bunnings, and George Columbaris as well, relatively large organisation. And that's because there haven't been these records. And the records certainly that are there are not showing that the employees are better off when they're compared to the award. So a lot of those have been either payroll errors because there's been a misunderstanding of what the award provisions were, or there's salary arrangements, in particular for management, salary arrangements that didn't cover enough, I guess. Now, George Columbaris is, as a bit of an example, he had a $7.8 million underpayment claim that was brought against him, which sounds like a huge amount and certainly landed him in some hot water in terms of the media in particular. Now, $7.8 million underpayment across a 6-year period, so it's approximately $1.3 million on an annual basis that he underpaid his employees. There were 515 employees affected. So if we do the maths, it actually works out to be less than $50 a week per employee, which is probably not hard to do if you're not applying a particular provision correctly. And one of the easiest ones to misapply, I guess, is like meal breaks. So when meal breaks are taken, if they're taken correctly at the correct time, and whether the payment is correct if they are not taken at the correct time. And so I guess in the case of George Columbaris, had he had an annual review of what was being paid, and that annual review was quite extensive, and it covered, all of the records that had been kept in relation to each employee when meal breaks were taken and all that sort of thing, it's quite possible that he might not have had such an extensive underpayment claim over such a period of time. So that's certainly the intention of the Fair Work Commission. Now, the main difference between the model clauses 1 and 3 relates to how an annualised wage arrangement is entered into. So you'll remember that I said that model clause number 1 applies to more stable hours, generally more consistent employment, consistent industries. If an employer chooses to engage with the annualised wages clause under these industries, they must provide written notice to the employee containing the various elements of the annualised wage to be paid. So that's what the requirement is. It just needs to be written notice to say, look, we're going to pay you X amount, and that amount covers your overtime for the year. It covers you working through lunch once a month. It covers you for annual leave loading. It just needs to list out those things. This differs from model clause number 3, which alternatively applies to employees or industries with highly variable hours and hours that attract significant penalties. If an employer chooses to engage with model clause number 3, there's a requirement for them to agree with an employee. So an agreement needs to be reached between the employer and the employee about the amount to be paid and what's incorporated with that salary. The parties also, at that point, say that you've agreed with your employee, okay, we're going to offer you this amount, it's going to cover these things. It's agreed because, and the idea behind that is because the hours are highly variable, and what is paid each week might not necessarily reflect what is worked each week. So it has to be a personal choice. But under this arrangement, there's also the option to terminate by agreement with 12 months notice. So if an employee and an employer are under an annualised salary arrangement, they don't like it, they don't like the arrangement, they can either agree together, so collectively, by consent, we agree to terminate this arrangement. Alternatively, either party can terminate the arrangement with 12 months notice. Now, 12 months notice seems to be quite a long time. It'll be interesting to see. Obviously, this has only been in effect since the 1st of March. It'll be interesting to see how that works because, as I say, 12 months is quite a long time to be unhappy with your arrangement, either as an employee or an employer. My feeling is that the 12 months was included because generally, if something's being terminated, such as an employment salary, it's been budgeted for. So for either party, it's giving them notice of a relatively significant change, I guess, to cash flow management. Because obviously an employee is not disadvantaged under that arrangement, so it wasn't the primary concern that the employee isn't receiving what they're entitled to receive. They can't be worse off, but it's more of a cash flow management, as I say. They're not necessarily paid. Their pay doesn't necessarily reflect what they work in a particular week. It's averaged out. Now, annualised salaries, the annualised salary provision, it doesn't provide an obligation to pay an annual salary in accordance with these new provisions. So there's no obligation to enter into this arrangement. It's obviously voluntary for employers. Now, the clauses do provide an extension of the current record-keeping obligations. So there always has been the obligation to keep employee records. I would say in particular in relation to salaried employees, those records probably haven't been kept in such a form as what is now required under these provisions, because it's generally, I guess, salaries come with a certain status, and it's not something that has been historically required that someone receiving a salary needs to record when they take lunch, for example, or their starting and finishing times and so on. The employee sign-off acknowledgement that hours are correct, so the hours starting, hours finishing, and meal breaks are correct. That's obviously relatively new as well, and that's for the purpose of just covering off those obligations. And it's about employee protection, but it's also about employer protection so that you have those records. And it also acts, I guess the fourth point there, it acts as a defence for underpayment claims. If you've been keeping your records properly, if you have had your employees sign off that the hours that they're telling you they've worked are correct, then it's obviously a defence for those underpayment claims. Now, in terms of, I guess, the takeaways, the sort of the to-do list, on the next slide you'll see what we're advising or what we're recommending is that you review your current annual salary contracts to make sure that those salaries are compliant with the modern awards. Salaries shouldn't be a set and forget. I know that there's certainly salaries out there that are well above modern awards, but Paul will take you through a couple of examples that really make you think, am I paying this person correctly if an award applies to them? Am I paying them correctly given that, they work through lunch quite a bit, or they stay late quite a lot, or they come in, every second Sunday to do some work, whatever it might be. So it's an opportunity for us to review the current annual salary contracts of employees. It's also an opportunity to determine the applicable award-covered employees. What award applies to them? Are we applying that award correctly? I would say that there are a lot of instances where the award isn't being applied correctly. I mean, that's evident given what we're seeing with these underpayment claims and wage theft claims. So making sure that we're applying the correct award, certainly. It also gives us the opportunity to assess the capacity to fulfill the award requirement. So having a look, as I was saying, having a look at those wages, having a look at that salary, is that covering what we're required to pay, what our obligations are under those particular awards? And if we make some changes, so if I want to add in some Sunday work or working through lunch or staying late or coming in early, do we have the capacity to fulfill our obligations based on what we're paying? And then the last one there, I talked about a little bit, but just the capacity to defend an underpayment claim. with record keeping in particular, but also just making sure that we feel good that we're not doing the right thing. That we go home at night and then we think, no, everyone's paid appropriately. We've got the records to show that they are, but we're also satisfied that they are as well. That's everything from me. So that's just, I guess, a little bit about what the annualised salary changes actually are, what they mean, what they do, and how we should be applying these, and what you should take out of this particular meeting. But I'm going to hand back at this point, and I know that Paul and Daniel have a little bit more to say on probably the less legal side of things, but the more practical side of things. Thanks,
That's
guys.
great. Thank you so much for that, Lee. Very, very helpful. Listen, I can see that there's been a number of questions that have come through, and we will endeavour to make sure that the questions are answered. As we progress now, we've obviously covered a little bit of the content with regards to where this has all come from and some of the legal perspectives. A lot of that can also bear some questions as to what does this mean. So what Paul and I will endeavour to cover now is to make sure that we can cover off, I guess, these four broad areas. The first is who is affected. We've obviously seen that first view of the Model Clause 1 and Model Clause 3 with who's affected. But just to understand that a little bit more, the next piece is a little bit more in depth of what is this annualised salary, and in particular, are we paying our employees enough? So in this area, Paul will actually go through some examples of how we would review this and how you might be able to put some of these practices in place. After that, one of the concepts that has come out of these annualised salaries is a discussion to do with the outer limit. So once I actually understand the amount of work that my employees are doing, how do I actually set the outer limits? The difference between Model Clause 1 and Model Clause 3, as Lee covered earlier, is that there is a slightly different approach to how I must approach that. Model Clause 1, you can do an update to the employees to be able to say this is what the outer limits are. Model Clause 3, due to the fact that those employees are a little bit more, working in environments, working in industries that are not as fixed, then there is some work to be done to be able to sit down and agree those details with the employees. And then the last piece is the record keeping. What does this mean? What are the requirements with regards to record keeping? And once you have the records in place, what actually are we going to be able to do with regards to that reconciliation? How do we go about the reconciliation? Through this, we'll also, at a very high level, touch upon if you are an Aussie Pay, an ePayroll, or an HR3 client. So one of the three main offerings that ReadyTech has today, if you are on one of those offerings, how we're going to make sure that you've got this covered and taken care of, so that you don't need to worry. But at the outset, our goal here is in the next session is to really make sure it's as practical as possible. So I'm going to hand over now to Paul, who's going to go through a little bit more about who is affected and some information on the annualised salaries. Paul, are you there?
Yep. Thanks, Daniel. I thought I'd just go and pop up the list of awards again with who is affected, so the Model Clause 1 and Model Clause 3. Over the last probably 4 months or so, I've been having conversations with different people, and generally I've found that there's sort of a flow or some stages that people go through. It's trying to work out if their employees are affected and what they need to go off and do. And that's very much trying to go off and actually get the right advice in regards to contracts and those types of things. We then move into, okay, well, now that I know what we need to do, or are we paying our staff enough? So that's what I'm now going to go off and move into, and I'm going to use some examples. So I've got James here. I've chosen the Clerks Award, mainly because it's sort of as wide-reaching as the awards that are there. I've chosen a level 3 category for James, just to try and simplify the calculations and do some comparatives as well. So I've got James on an annual salary of $50,000. Award states that the minimum weekly amount is $911 at the moment. And that works out, if I go off and times by 52, to give us a salary minimum for James of $47,372. So on the face value, if we go off and just look at that there, we're paying James above what the award minimum is in regards to the annualised salary. I've got the hourly rate showing just there, because I'm going to use that, because I find that going off and doing things in regards to hours is generally easier. So I'm going to go off and divide that difference. Looking a little bit deeper though, okay, in each July we've got a CPI indexation that comes through the awards. So I've built into my estimates for James here that I'm going to have a 4% CPI increase. Don't think it'll be quite that much, but I'm putting that in as an estimate to make sure that I'm not caught out. So the base salary is now looking like $48,319. The award states that we've got leave loading, which is another $600, which leaves me in James's salary only $1,000 to play with. So if I go off and use the hourly rate, I can convert that into the number of standard hours as a buffer. And I like doing that because the standard hours is sort of a little bit more relative and easier to go off and understand. So whilst it looks as if I've got a little bit of money up my sleeve and I'm fairly comfortable with what I'm paying, if we go and actually look at that standard hours buffer, and a couple of things that could go off and happen. So if in a month, on average, James does 3 hours worth of overtime, that works out to be 54 standard hours. Okay, so that's working that out just at the 1.5 times rate. So if James is expected to do 3 hours of overtime each month, I'm going to be in trouble come the end of the year when we go and do a reconciliation and making sure that he's better off. A couple of other approaches or things that may happen. Okay, if we had James starting 1 day a week at 6 o'clock, so starting in the penalty rate times before 7, that would work out to be 55 hours, okay, across the course of the year. Okay, you might turn around and go, okay, well, James shouldn't be going off and doing any overtime, and he's very junior, so I'm not expecting any of that. Okay, but the one item that generally catches people out is if at any time you ask James to work through a lunch break. So if James was in a finance department, okay, and come end of month trying to get everything out, and you find that he's working through lunch once a month, okay, the penalty rates that would then apply, okay, because of not having the break, works out to be 72 hours. Okay, so if we go off and work those back, if we have any of those situations, okay, we may have underpaid James. Okay, so one of the things that I generally recommend that you go off and do is go and look at your existing employees on annual salaries, okay, and go through that process to go and work out, okay, well, with the different amounts that they should get paid, okay, if you are actually paying enough at the moment. Okay. Also go and look at what they're doing to go off and see if you do have anything to be able to go off and ask them to do overtime and those types of things. Now, that's going off and looking at the annual basis, and that'll help you put together effectively what you'll have in your agreement to give to the employee. The other item that we need to go off and look at are outer limits. So there are 2 outer limits that you need to go off and set, okay, and this needs to be in the agreement that you either provide to the employee or get agreed to with the employee. Okay, so you need to go and set the number of overtime, okay, and penalty rate hours that an employee may be required to work in a pay or roster cycle. The pay and roster cycle is going to be important depending on how you or what your pay cycles are, okay, without being entitled to any additional payments. Okay, so this is where you go off and work through, well, how much overtime do we expect? Okay, and if the employee works outside our outer limits, either at overtime or penalty rates, okay, would need to go off and actually pay them more. Okay. All right. So I've got another example here. So I've got Sandy. Okay. I've kept the same award and category just to try and go off and make the calculations a little bit easier. Okay, so Sandy's on $65,000. You'll see each of the other items have worked out exactly the same as James. Okay, and I've just got a note down the bottom that I'm paying Sandy monthly. Okay, the outer limits that you set need to be based on your payment frequency. Okay, so going through the same sort of calculations, okay, I've got my base salary with my 4% CPI, the leave loading that we had, which leaves us with $16,000. Okay, so we should be able to go off and have a little bit more overtime and those types of things with Sandy here. So with Sandy's contract, okay, the employment terms that we've got is that she'll be working, okay, one Sunday a month. So we've got a team of 4. Okay, so we're expecting her to do a 6-hour shift on a Sunday, generally about 3 hours worth of overtime each week. Working in the finance team, okay, Sandy may need to work through lunch 2 days a month, okay, with some penalty rates, okay, and we'll need to go off and start at 6 a.m., okay, 2 days a week. Anyone going off and doing the maths crazily in their head, I've still got around about $600 up my sleeve going through those other calculations, okay, or about 27 standard hours. All right, looking at these items here and our expectations of what Sandy should be doing, okay, if we've got the 6 and the 13 for overtime and the 6 and 8.6 for penalty rates, we could go off and think we'll give ourselves a little bit of a buffer, okay, and we could go and set our overtime outer limit at 20 hours, okay, and our penalty rate outer limit at 15 hours. Okay, and a lot of people will have been going off and looking at those types of things and choosing those types of figures. Okay, but what if, okay, and these are items which you might have a little bit of control over, but you may not necessarily. What happens if in my team of 4, okay, they decide to go off and swap Sundays? So I've now got Sandy working 2 Sundays in a month, which has now jumped the actual amounts. If 5 Sundays fall within a month, okay, so this month, okay, we've got 5 Sundays. Okay, so these types of items can go off and then impact the total hours that are falling. The other item is seasonal workloads. So in certain roles, there will be periods where you need to go off and do more overtime to get things done. So if the clerk is working in, say, your finance team, come end of financial year, okay, maybe a 6-monthly audit, you may have different points in time where you'll do different amounts of overtime. So with that, you don't necessarily just want to go off and work through an average. You want to go and look at the overall work pattern that you may go off and have the employee work. So just using my figures before, I think if I just averaged the overtime across the course of the year, I think it came in at around about 13. But come end of financial year and end of the 6 months, okay, I could have much larger overtime. So by going off and actually looking at these types of items, okay, you may then go and choose to set, say, your overtime limit at around about the 25 to 30 hours. That could go off and get a little interesting, engaging with the employees and trying to put something in front of them in regards to, okay, well, yeah, and each month I've got this outer limit of 30 hours of overtime. So there is a lot going on there, and definitely need to go on. Be careful with your interactions with your actual staff when presenting them. Okay. Right. Daniel?
Perfect. So yes, it's probably a good point in the slides to sort of take a pause from some of the technical and have a think about most of the information that Paul has sort of taken us through so far. Really point to the fact of the need around that record keeping. Now, one of the things that the annualised salary changes have actually done more than anything else is pointed a spotlight on the record keeping section. And what do I mean by that? The record keeping requirements have been there for well before the introduction of these annualised salary changes. And in fact, as salaried employees, full-time employees, there has been a requirement for employers to be able to track their employees' hours well before these annualised salary changes. And that's really the primary driver behind that is for that, what we call it, generally speaking, the better off test. And what does that mean is at any point in time, Fair Work can come knocking and ask the question, based on the salary that you're paying your employees, how do you actually know that they're better off getting a full-time salary as opposed to actually being paid under the award as per the rates to do with overtime, to do with working through lunch breaks and whatever it might be. So what's really important to remember out of this is there's some really strict requirements that historically businesses have not really adhered to, employers have not adhered to, and that sort of opens us up to a little bit of a risk. So what are these requirements? Ultimately, many of you today are AussiePay, ePayroll, or HR3 clients. So the first piece of recording what the rate of remuneration paid, the gross to net amounts and so forth, are all taken care of in your software application. That's generally speaking well documented across the board. The next piece is where we all generally need to have a think about how many of our employees are actually doing this, and that's clocking the time. So what we mean by clocking the times is we need to know the start time, the finish time, and the unpaid breaks time. It's really important. And it's not just I worked 5 hours, then took a break, and then worked another 5 hours or whatever the timing might be. Ideally, what we need to know is the times that those things actually happen, because then that way you can actually factor in whatever penalty rates and so forth need to be taken into account should Fair Work ever come asking. Now, a lot of questions have been coming through on the question Q&A section, and we've been asked this question a lot: is it all right if my employees to track the time and I don't? Our recommendation is absolutely not. As Lee mentioned right at the beginning, this is all about how the employers have got a documented history, so that should there ever be a claim or anything like that, that you actually have the information necessary for yourself. Fair Work actually have an app. And what I'll do is I'm just going to read the opening line on their website of the app. The app is positioned to employees. So anyone that's an employee can actually download the app from Fair Work. And the interesting part of it is the way that they sell this app or the way they position it. And I'm reading verbatim from their website. Sometimes employers fail to properly keep employee records. The lack of records make it difficult for an employee or us to address concerns about underpayments. So really the whole idea about these changes, the whole idea about why the annualised salary changes have come into effect is to really make sure that the employees are being paid adequately and fairly and that they're protected. And so from the employer's side, what's absolutely fundamental in the requirements that we have is we have to be able to have these key pieces of information gathered. Now, the next piece then is the acknowledgement. Okay, it's not just good enough that I clock in and walk out at the end of the day. That isn't deemed to be acknowledgement enough. What really needs to happen, and you need to ultimately have systems and processes in place, is that I can clock in the morning, clock out at the end of the day, clock any of my unpaid paid breaks that have been taken. But ultimately, at the end of a said period, whether it's a roster, a pay period, whatever it might be, there has to be an acknowledgement by the employee to say, I work these hours. Now, if you use Aussie Pay, ePayroll, or HR3, we do have an ability to enable timesheets for you. In the application, your employees will be able to log their times with the requirements as we've just discussed. And at the end of that said period, they will submit those timesheets to their manager, and that is the acknowledgement of them saying, I have worked these times. Okay. Now, the question that also gets asked is then, what happens if I don't ask my employee to work during those times? They just decide to work outside of that. And we can ask Lee this question at the end more from a legal perspective, but practically speaking, it comes down to, are you asking your employees to work that amount of overtime, come in early, work late, work through the lunch period or not? If you're asking them to do that, then absolutely that opens you up to be able to make sure that you've got the right requirements in terms of these outer limits. But ultimately, if an employee is choosing to work a little bit harder, do that extra work, a reasonableness test effectively needs to be applied to say, am I giving this person too much work? If I'm not explicitly asking them the question, the real thing is, am I giving them too much work that they cannot actually get through their day as a result of this work? Because then there may be an implied request for you to work longer hours. So there is some practical application to that. And that's, again, through this, I will keep pointing back to the fact that you probably need to seek some advice and work out how you're going to actively manage this within your system, within your processes internally within your organisation, because this is a whole of business approach. This is not and absolutely cannot sit with the finance department or the Office of Payroll. That's something we've absolutely seen. You can't just wait for that information to come to you and be blind to the practical implications of if managers are asking people to work through their lunch breaks. Okay, so that information is why that clock time is really, really important. And then the last piece is we have to be able to keep it. In fact, our prescribed records under law here in Australia says we need to keep it for 7 years. And I believe actually it's 7 years from the point that the person leaves. So if the employee's been with you for 10 years, there's a question to be asked with regards to, is it actually 17 years I need to keep that information for from the date they started? So it's 7 years from when the person leaves. So there's clearly a lot of information that we need to gather. Now, once you have all of those clocked times, you have the acknowledgement for the employees, the question is, what's next? How do I deal with this? How do I know if I'm paying my employees right? And if I need to do a top-up? And that's what Paul's going to take us through now.
Thanks, Daniel. So starting to work through, the checking that everything is happening. Okay, so we've got 2 reconciliations that you need to go off and look at. So there is a reconciliation that you need to do each pay cycle or each roster period. Some places may go off and pay people on, say, a fortnightly basis, but they may go and roster people over different hours at different times over a longer period of say, a month. Okay, so the other item which will generally go off and fall with the roster period is if you pay monthly and you pay, say, middle of the month, okay, some in advance and some in arrears. You can't, at the pay cycle point in time, know the hours that the employee is going to do in those future weeks. Okay, so you'd need to be going off and doing the reconciliation here, okay, at the end of the roster period. Now, the per pay or roster period reconciliation, okay, is to compare the hours that have been worked to the outer limits. So that's looking at both the penalty rates and the overtime. So to be able to do that, you must have a record of the time that the employees have worked, okay, including their breaks, so when they took their breaks. Okay, that way you can actually then work out, okay, what the penalty rates are, okay, or any of those overtime items. Okay. Now, with this, okay, you generally need it to be reviewed, okay, because as Daniel was saying, okay, was it that the was it employer directed, or did the employee just decide to turn up early and clock in and then go sit in the kitchen for half an hour, 45 minutes, chatting to people, having a coffee before work? The other thing is that there may be people having flexibility arrangements, okay, time in lieu. Okay, so someone may have gone and done a little bit more time here, okay, to go off and then get some time when it suits them. Need to be careful with time in lieu, okay, because the time that the employee does actually do the work, okay, if that would be at a time that there would be penalty rates or say double time, the time in lieu gets used up at whatever the rate is at the time that the employee is doing it. Now, once you've done that comparison, okay, if the employee has worked outside of their outer limits, either overtime or penalty rates, you need to go and pay any additional amount in excess, okay, to the employee, okay. With this, it is an additional payment to the employee. You can't go and offset it against a time where there's not going to be as much overtime and actually claw some of it back. So if your employees work outside of the outer limits, okay, your salary and wages bill is going to go up. Now, when you are going through and looking at this here, okay, one item or one word here that I'll go off and point out is that you need to go and actually pay the excess hours at the corresponding rates. So you don't get to choose which of the overtime that you're going to pay the employee. Okay, so you can't go off and pick all of the 1.5 hours. Okay, you look at how much overtime through the course of the pay cycle. Okay, and once you get to the outer limit, any of the additional items or additional hours would get paid at whatever the rates those hours would be paid, okay, had you been paying that employee hourly rates. Now, in regards to the amount that you need to go off and pay, okay, you do need to go off and actually check back against the award, okay. Some awards will go off and say that you need to pay it at the employee's rate. So you might want to go off and stipulate in the agreement that you get with the employee what that rate will be. Some of them will be at the minimum award rate, okay, but it can vary based on the different awards. So you want to go off and actually check that, okay, or possibly pop something into the agreement to make sure that you are covered, okay. And anything can't be recovered against future periods. Okay, so we then have an annual reconciliation. So I've put annual here, but it can happen on termination of the employee, termination of the agreement. So if they were in the model clause 3, if they turn around and go, yeah, I don't want to get paid annually anymore, and they'll take the 12 months for it to wind out. It also needs to be done wherever there's a material change within the employee's role or salary. Okay, so if you go and do an annual pay review of all of your staff, okay, and salaries change, you may need to sit down at that point in time and go through and do a reconciliation of the amounts that have been paid, okay, and then put in place new agreements. So the requirement here is that it is done at a minimum annually. Okay. Now, when we do the annual reconciliation, we actually need to go and compare, okay, what the minimum amount the employee would have received for all of the hours across the course of the year or the reconciliation period that you're doing versus the salary that they have received for that same period. And if there is any additional amount that they should have received had they been getting paid on an hourly rate, okay, you're required to make a top-up payment to the employee within 14 days. Now, with the outer limits, they're there very much to let you know if employees are doing too much time, things that you're not expecting, So when you get to this annual reconciliation, okay, you don't have a massive cash flow issue because you've found your employees have done additional hours and work that you weren't sure of. So the idea around the outer limits is really sort of an early warning system for you and the employees. It's also to make sure that the employees don't have to wait until this annual reconciliation occurs if they are doing lots of additional hours.
Perfect. So before we go into the Q&A side of things, I guess the key things, and I will recognise that we have had well over 100 questions, so we're going to do our best to try and summarise the questions. But before I do get into the questions to be able to get some answers, the key points and the key takeaways, if for nothing else, everybody can take away from this is, A, that record keeping requirement. Okay, so the need for employees to be able to track the time that they work, acknowledge the time that they do work, and send that through to the employer is really important out of this. Managers need to understand what the implications of this are, and then obviously what the implications of those outer limits are as well if you go down that path of annualised salaries. If I step back, one of the things that's also really important through this is then how you're going to be able to do that reconciliation that Paul mentioned and have that understanding. So the good news, again, if you are an Aussie Pay, ePayroll or HR3 client, we do have your back. We, in addition to adding the ability to track the timesheet, we will be adding reporting through the platform that not only will you be able to store what the outer limits are within the application, so within the employee area. For each employee, you can actually store what the outer limits are, and then what it will do on each pay period or at when we set it up and configure it for you, a report will be created that gives you an ability to be able to see and report against those outer limits, so you have that information at hand. So if you are an ePayroll, an Aussie Pay, or an HR3 client, you will have that covered. In addition to that, if you're an Aussie Pay client, we can actually do that full reconciliation process for you as well as part of our services. So again, if there are some questions with regards to that, we're more than happy to help you with that. If I step then into what that all means is, obviously we've got to be thinking about that pay frequency and how you're going to manage that. When setting that outer limits, the important piece is also having that fair conversation with your employees. Now, I'm in just a moment's time, I'm going to introduce Andy from Flair. The reason why we've got Flair on the line is that part of the challenge with these conversations is managing and balancing that beam of the seesaw, you could say, of saying, going out to your employees and say that, we're agreeing that there is these are your outer limits, and then trying to balance that, because a lot of this goes against what we've been trying to build in organisations about flexibility, about building the right culture within an organisation. Now, unfortunately, this in some respects does go in the face of that, and there's nothing much we can do about that in terms of the legal requirement, but it's how it's delivered and what else we can deliver to our employees that help balance the beam, and that's where Flair come in. So I might flick over quickly to Andy and ask him to give a really quick overview and an introduction of where Flair can help with this process as well.
Great. Thanks a lot, Daniel. Appreciate you giving us some time on the webinar today. And look, we've heard a lot today around the impact on teams in terms of compliance and record keeping. And I think what a lot of people will recognize is that there probably isn't a lot of time in the day to handle everything that folks are going to need to deliver as part of keeping their teams compliant with this. So if you're not familiar with Flair, we offer a free digital onboarding HRIS and employee benefits platform. How we can help in the context of this annualized salaries change is really the foundation of this sits around compliance. Our customers that use our digital onboarding, their record keeping starts with that, and with the digital acceptance and e-signature of those contracts, and in alignment with fair work record keeping. And really what we've been talking about today is a lot of contract variations. So folks that currently have a contract and needing to set things like outer limits, that's a lot of manual, tedious work for HR and payroll teams, which are usually the most under-resourced teams in the business. So as an example, with the customer that updates the contracts for 300 of their employees every year, with updating the end date of those contracts, and they can push those kinds of updates out to about 300 employees in about 5 minutes. So there's tools out there that can help you to streamline those aspects to it. And that's really important because you want to be able to give time back to your HR team to have to help to empower managers to have those real one-on-one conversations with the staff who are affected, who, even though their working arrangements aren't really changing all that much, now they've got something in their contract which might say they've got 30 hours in an outer limit that they need to accommodate for, which can be a bit of a tough conversation for somebody. And we know that, to Daniel's point, that a lot of businesses have been trying to strike the right balance on things like flexible work and wellness programs. And when you're an HR team that's now got a compliance mountain decline, those are usually the programs that suffer first, and the ones that are first to drop off. So the last area where we really help businesses is around our employee benefits. So we have a free employee discounts and perks module, part of Flair, and it is going to be an increasing part of our ReadyTech partnership. And this is sort of a really nice way to try and amplify all the other perks and benefits that exist as part of working in your organization, that might not be front and center when you're having a conversation about our limits, but gives helps to give folks a reminder of all the other tertiary benefits that are a part of working at the organization. Now, I know there's a ton of questions. I won't take up too much more time than that, but certainly if you're interested in finding out more, our website's up there. And again, my name's Andrew Anderson. Feel free to reach out.
Great. Thanks for that, Andrew. So we might just step back, Paul, one slide, because I think, just to give a little bit more of a plug and introduction, I've mentioned HR3, ePayroll, and AussiePay. More recently, ReadyTech have launched a new platform really targeted at helping organisations that do want to have a true all-in-one solution to help manage that. So HR3 Plus actually has a time and attendance, payroll, and human resource management platform all on one, all seamlessly integrated as one platform. So for organisations that are struggling to work out what approach you may want to take to this, as existing clients of ours, as well as potential prospects that may be on the line, we've had well over 1,000 people register for today's session. We are able to help with the gamut of those solutions. So on that point, I'm going to pause there. We've got a lot of questions. I'm going to ask Lee first to unplug, and Paul will just shoot over perfect. Lee, if we can unmute you. There's been a few questions, in particular in regard to are annual salaries compulsory, and what about the set-off clauses? Are you able to help us sort of navigate the difference between those?
Yeah, perfect. So I can answer that. I've seen a lot of questions come through, annual salaries compulsory. Certainly not. Annual salaries under these provisions are certainly not compulsory. It's an employer choice. In relation to that model clause number 3, it's an agreement between an employee and an employer. So absolutely not compulsory. In looking, I guess there's been a lot of questions come through in relation to set-off clauses and contracts that have annual salaries and those sorts of things. And a lot of the questions have been along the lines of, can I do that instead? Do I still need to comply with these obligations? In short, I would say that, look, these obligations are effectively the Fair Work Commission's view on their treatment of annual salaries. So at the end of the day, you can pay an annual salary. You can have a clause in a contract that pays an annual salary that's not covered by one of these annual salary provisions, that's not covered by one of the awards that we've discussed today. But at the end of the day, you still need to be keeping your records. So it's not a get out of jail free card to say, well, it's in my contract. It's not an annual salary that comes under these provisions. You're still advised to have and keep those records. Whether that looks like a sign off each week or each month or each pay period or something like that. That's a choice. We certainly recommend that you maintain those records, however, because and I think it's something that Paul certainly said throughout this seminar series. Things will go right until they go wrong. And we're in the day and age of record keeping, and it certainly, I guess, is wise to be keeping records even if you're not paying an employee under one of these arrangements in particular.
Okay. So somewhat related to that same question is that there's been a number of questions about some really specific awards, manufacturing, food, beverage, tobacco. If my award that I pay my employees under is not on that first list that we displayed, does this affect me?
No, not necessarily. Not specifically. Your award may not be affected if it wasn't in those lists. It's not to say it won't be brought in the future, but as I sort of said, these provisions are a reflection of how the Fair Work Commission is treating annualised salaries. Whether it's in an award or not, very much the view of the Commission is that employees cannot be disadvantaged when it comes to receiving an annual salary. So at the end of the day, yes, the award may not be affected, but if you're choosing to pay an annual salary, it still cannot disadvantage an employee. It still can't be less than what the award is prescribing. So those things remain unchanged.
Okay, but I'm still right in saying that despite these annualised salaries these annualised salary changes not affecting them, the record keeping requirements are still one that would affect to irrelevant of the award.
100%, yes. Exactly right.
Okay, perfect. And then again, somewhat related, if there are CEOs out there or senior management, does this cover everyone? Does it cap out at a certain salary?
Look, award coverage, it doesn't. It depends, I guess, is the answer to that. It depends on the award coverage. If you're an award-covered employee and you're an award-covered CEO and you're earning, 10 times what the minimum rate of pay is, it's still recommended that those records are maintained, just for the purposes of, when is work being performed? Are we falling short of our expectations? I'm quite sure that someone's earning 10 times more than the minimum rate under a modern award is probably not being disadvantaged, but I guess the expectation is that you keep those records, and that's the requirement of the modern awards.
Okay. Now, maybe Paul, you can help answer this one. What happens if people work longer than required? They decide to work through their lunchtime, or in some cases, I need to leave early and pick up my kids from school, but then I'm going to log in at night. Well, practically, what does that mean?
So if someone's going to go off and leave early and then log in a little bit later, you need to be careful in regards to the penalty rates that may apply to the time that the employee decides to do the make-up time. So if they leave to be able to go and pick the kids up and then decide to go and finish their 2 or 3 hours after 8 o'clock once the kids have gone to bed, those hours will be worked at a penalty rate, which will effectively mean that the employee doesn't need to do as many hours because they are working in a penalty rate period to make up the time in lieu that they did within the normal hours. So some employers may decide to go off and reduce the amount of flexibility that staff have, so that they don't have people going off and working at times that could theoretically cost them more. So it's not something that I like. I personally like going off and having the flexibility. But some employers may turn around and go, well, we don't have enough in our annualised salary to be able to cover that. And whilst it's generally okay, whilst everyone's happy, when an employee isn't happy and they start recording their times and those types of things, that's when the issues can go off and crop up.
Okay, great. We've just got time for maybe one or two more questions. I know there are a lot, and I've tried to see that we could get general responses to them. A very quick one for you, Lee. Am I right in saying that this only affects full-time employees, not part-time?
Yeah, so these provisions can only be applied to full-time employees. It's not to say that you can't have arrangements with your part-time employees within an employment contract, but these specific provisions, they're very much set, so they only apply to full-time employees.
Okay, and if I have a time in lieu process already with my employees, does this affect that? Am I still able to have time in lieu?
Look, you still can. You should consult your specific award to make sure that that's an arrangement that you can have with your employees, but it certainly doesn't prevent you from having those other arrangements in place to offset over time when that's worked. Certainly not.
Okay. So just on the last one, there's been, and we're going to stop it there, but there has been just a lot of questions about how often do I need to do the annual reconciliation? When does that apply? So I might just answer that. There's one that really you need to seek some guidance yourself. The guidance that Lee has definitely shared is that you need to do that annually, the reconciliation. When does that reconciliation need to happen? Ultimately, there is no defined period that needs to happen in terms of defined date that it needs to happen. It just needs to happen at least annually. A number of our clients, though, have been informed by their counsel that they need to do it more frequently than when somebody, annually. In particular, you absolutely, upon termination, one thing that you may want to consider is if there's a substantial change to somebody's role. So if they move roles, whether or not you need to be doing one then. And then again, a lot of our clients have been seeking advice and have been told that they need to be doing it for each pay period. So whether that's weekly, monthly or fortnightly. Either way, as Aussie Pay, ePayroll and HR3 clients, we will have a solution for you for however often you wish to take and do that reconciliation, as well as, most importantly, have the ability to track the times, have the acknowledgement from the employees and push them through to the managers so there is that acknowledgement there. So all that is available. Some more information will come following this event on how you can activate those services. At the end of this webinar, as you log out, it will ask you for a quick survey. So I please ask that everybody fills in that survey. Your information, your feedback on what worked and what didn't work on this webinar is always great. And then the last thing is as well, a recording as well as the slides will be made available shortly to you, so you can share this with anyone else in the organisation, because, again, this is a whole of business approach, not just the Office of Payroll or Finance. So thank you so much for your time today. It truly was a pleasure hosting you, and we hope everybody stays safe in these uncharted territories. Thank you.